Do you see Operation Sindoor as an act of self-defense?
So even assuming that the Security Council resolutions have referred to right of self-defense, but they are not explicit to state that even if it happens from a non-state actor, the victim state can use force against the other state.
Hello, everyone, and welcome to another episode of Justifying, the Law and Policy podcast from the Vidhi Center for Legal Policy. Today, we are discussing an exciting issue, which is the Operation Sindoor and the use of force and self-defense. In the wake of the cross-border terror attacks in Pahalgam, India launched Operation Sindoor, targeting alleged terrorist camps across the line of control. Supporters argue that it was a legitimate act of self-defense under Article 51 of the UN Charter, reflecting a global shift in legal interpretation. Critics, however, question the legal justifiability of expanding self-defense to non-state actors within sovereign states, raising concerns of misuse of international norms. To unpack these legal dilemmas, we are joined by Professor Srinivas Burra, whose work specializes in third world approaches to international law and critically analyzes India's evolving state practice, especially the application of the self-defense doctrine. As part of it, we'll also be looking at the problematic unwilling or unable test when actions against states are justified in the face of their failures, unwillingness or inability to act against non-state actors in their territory. This is a doctrine that's been created by the global north in that sense. So we will see what its applicability in this current situation is. Dr. Srinivas Burra teaches international law at the South Asian University in New Delhi with a focus on the law and the use of force, international humanitarian law, and human rights. He has previously worked with the International Committee of the Red Cross and the Asian African Legal Consultative Organization. Professor Burra, it's a pleasure to have you on Justify. So we'll jump straight in. As an international lawyer once said, there is no more important question of law in international law than the proper limits on the right of self-defense. As an international lawyer, do you see Operation Sindoor as an act of self-defense?
Yes, okay. Yes, probably I think there has been a bit of a discussion in and around the right of self-defense after the Operation Sindoor. But there was not much of an emphasis also with regard to the legality part of it. It was more being looked at as an anti-terror activity. But before getting specifically into the Operation Sindoor incident, probably I think we need to look at it as how the international law legal framework regulates the use of force, and especially the use of force when we say use of force in interstate relations, because without getting that at least into the foundational aspects of the legal regulation part, probably we may not be able to appreciate much as to what the right of self-defense constitutes as part of international law. So if you look at it, at least from the post-1945 establishment of the United Nations at the end of the Second World War, the one major development, at least from international law and relations point of view, is that the complete prohibition of use of force. Now, this is very explicitly stated as part of the UN Charter, Article 2, Paragraph 4. So, in other words, at least from 1945 onwards, there is no possibility of having a legal war between two states. Now, this is a general prohibition, unless it is justified with the two exceptions. So, which is a general prohibition at one level, which is Article 2, Paragraph 4 does, but the same UN Charter provides two exceptions. So, one exception is the right of self-defense, which is individual or collective self-defense, as which is provided as part of Article 51 of the UN Charter. So, this is one exception to the general prohibition. The second exception is the authorization of use of force under Chapter 7 of the United Nations Charter, which is broadly referred to as a collective security measures. So therefore, whenever we look at any interstate use of force now, post 1945, if one has to evaluate it in an international law sense, we cannot escape from these three aspects. That is a general prohibition at one level and two exceptions. And quite often, at least the post 9/11, or you can say post Cold War and the post 9/11 incidents, the right of self-defense under Article 51 has come under strain. I say it as a strain because quite often it is being used, whether it was in the case of Iraq War or in the case of Afghan war after the 9/11 incidents, or in the case of Syria, in other cases, which in fact things are happening now, including the debates in and around Israel and Gaza, as well as Russia and Ukraine. Almost these are the provisions which are always used. And quite often, reliance is based on the Article 51 of the UN Charter. Now, Article 51 of the UN Charter very clearly says that a state, either individually or collectively, can respond to an armed attack that takes place in its state. So this is what broadly the provision is that. So any justification that has to come from, if any use of force has to happen if a state is individually claiming it without the involvement of the Security Council. It is essentially this provision which has to provide the legal basis. Now, what does this provision talk about? Because that is where the most of the debate and kind of a legal interpretations come in. It says that a state has a right, can respond to a particular attack if an armed attack takes place on a state. Which is, in other words, an armed attack has to take place. It is not that something that it can take place or you are preempting something. At least going by the language of 51, an attack has to take place. But the interesting part of the language of Article 51 is that it is silent about where from the attack comes, in the sense that whether the attack should come from some other state, or it can also come from other than any other entity other than the state. In other words, largely it's the non-state actors or quote unquote terrorist groups of any name. So,
So as a municipal lawyer, sorry if I were to
yes,
interrupt you,
yes.
if it is silent on the question of where from this attack emanates from,
Yeah.
one could assume perhaps that it could emanate from any source, whether it is another state or a non-state actor. Would that be correct?
Yes, that is a fair interpretation of the silence, that is the options or the silence that exists in 51. But the issue is that whether 51 has to be read in isolation or should it be read in along with the provision which is a general prohibition, that is Article 2, paragraph 4. So when we look at Article 2, paragraph 4, the language of it is essentially talks about interstate use of force. That is a prohibition of interstate use of force. So therefore, then a logical explanation could be that when a general prohibition itself talks about interstate prohibition, the use of force in interstate relations, is it possible to read something from an exception that it can also provide the possibility of attack coming from some other entity other than the state? And also, if you look at the other exception, like for example, exception under Chapter 7, that is a general prohibition. In all the circumstances, of course, it is an interstate use of force that is central to the Chapter 7 powers, except, or one can say that there are two resolutions which were passed after 9/11 incident, two Security Council resolutions, where they refer to right of self-defense of states, but they are not explicit that they just refer to recognizing the right of self-defense of a state when such attacks take place. But it does not refer specifically coming from where, whether it is being attributed to the state or not. So even assuming that the Security Council resolutions have referred to right of self-defense, but they are not explicit to state that even if it happens from a non-state actor, the victim state can use force against the other state. Now, this is what Article 51 and Article 24, at least at a personal level, I believe that.
Broadly speaking, again,
Yeah,
please
yeah,
pardon my naivete because I'm
yeah,
not an international lawyer. But
yes,
if the general prohibition is on the interstate use of force,
yes,
you're right in saying that perhaps the exception cannot be wider than the rule. Then the
yeah,
exception is also on, I mean, is essentially related to the interstate use of force. Then what happens to non-state actors? Now, there are only two possibilities. One is, as you said, that we can say that it is part of the exception. And maybe by implication also it is part of 2.4 because 2.4 is intended to be comprehensive. Or alternatively, that nothing in the UN Charter actually imagines or envisages non-state actors, and so it does not deal with that issue. That issue is left to be dealt with elsewhere. So
so,
in either event, it would seem that there is perhaps a good case for, and I'm not getting into India's actions yet, but there is a good case for the state, whichever is the victim state, to respond against non-state actors on another territory.
Yes. Now, there are two possibilities. One is that it's not that completely, international law is completely silent about the actions by non-state actors. There is one possibility, that is that attributability. This was developed by the International Court of Justice, very explicitly stated in the Nicaragua case that if the actions of non-state actors can be attributed to the state, then of course there is something called an effective control and overall control test. But either of them, if there is if the non-state actors' actions can be attributed to the state, then state could be held accountable for the actions of non-state actors. So that is one possibility. But the second possibility could be that if the state is not involved at all, in the sense that non-state actors are operating from the other state, but there is no link between the state, or a state is not playing any role in terms of supporting the activities of the non-state actors or no. That is where some state practice has evolved in the last, again, I say 2 to 2.5 decades, that it is specifically coming from certain global northern states. Those were also part of the P5, that's the permanent 5 of the Security Council, is that if the state from which territory the non-state actors are operating, if that state is unwilling or unable to control the activities of the non-state actors, then the victim state has the right to use force against the other state. Now, there are two things that would come up. One is to say that when a victim state uses force against the non-state actors, one way of looking at it is that, okay, it is not attacking the state or state as a state territory, but it is only targeting the non-state actors. Could be one possibility. The other is that even assuming that an attack is on the non-state actor, but it is taking place on the territory of the other state, therefore it would amount to the attack on the other state, or the use of force against the other state. Now, this was explicitly stated by one of the studies by the International Law Association study on use of force. It said that even if the attack takes place on non-state actors, it cannot be said that it is not on the state. It is on the territory of the state which is taking place.
That's right. It does affect sovereignty.
Yes, it does, because it's a sovereignty and integrity of the state. So
The
therefore,
territorial sovereignty is certainly affected.
yes, sir, yes.
Yeah.
So therefore, there is no possibility of arguing that you are only specifically targeting the non-state actor from there. There comes the question of the inability and unwillingness test, which is what is being invoked predominantly by in most of these global.
And so you have written quite widely about this, including a sort of an excellent Twail account of this unwilling and unable test. And so this seems like we are in a slightly curious situation here, because the unwilling or unable test, as you said, has been propounded by countries in the global north. It's a test that perhaps is not as respectful of territorial sovereignty. It also lumps together two terms which are not at all similar. Unwilling is certainly a very different threshold from unable for sovereignty to be affected. We have heard murmurs of Israel claiming the unwilling or unable test in order to carry out some of its actions in Gaza. Now we find ourselves in a curious situation where India, of course, can take a traditional definition of Article 51 and say that this is, as the Foreign Secretary was saying, this is our right to respond, and go by the Nicaragua test, that this is essentially part of the Pakistani state apparatus, whether directly or indirectly, and try and fall within that parameters of overall control. But India could also, as a much lower threshold, use this unwilling or unable test, because it's a much lower threshold for India to meet. So when a country in the global south now finds itself in this position of a victim, as India does find itself in at this point of time, uh, where do you think the penny drops as far as its usage of unwilling or unable? Should we be pragmatic, or should we continue with a principled stand that this test has some difficulties insofar as territorial sovereignty is concerned?
Yes, I think the answer lies somewhere between the pragmatism that you referred to, and also in certain respect, there is also a principled position in certain respect. Now, if we come back to specifically Operation Sindhu's use of force, to be contextualized, probably we need to look at a few developments that have taken place in relation to India in the last roughly 10 years or so. Now, there are three broad phases that one can come across in relation to this. One is that before Operation Sindoor, and at a similar level, India was part of the two other strikes, which took place again in the case of Pakistan itself, which was in 2016, the surgical strikes incident, and again the Balakot incident of 2019. Both are similar, but of course the intensity varies. Now the intensity is much higher than the previous two occasions. But the situation more or less is similar. In a factual sense, it is a non-state actors operating from there. India responded to both of. In both the situations of 2016 and 19, India was not explicit in terms of invoking its legality part of it. It did refer to its right to respond to, and specifically said also that it is only targeting the terrorist hideouts, locations, which are not specifically military operations in the sense of interstate use of force. So in both the occasions, it was not explicit, though its language, its positions have gone closer to invoking the right of self-defense and also to some extent unwilling or unableness, but not explicitly relying on that part of it. But there is a significant change has happened after 2019, that there was something, an interesting, important meeting took place in the United Nations Security Council, which is a ARIA formula meeting. It's not specifically as a Security Council formal meeting, but it's an informal meeting of the Security Council members. And that meeting was specifically with regard to the use of force against non-state actors by states, and what are the states' opinions. So it was an informal meeting, but all the states have made, or good number of states have made formal statements in that meeting. And specifically, it was with regard to the use of force against non-state actors. Now, in that meeting, India was very clear, explicit in its position, stating that the states have right of self-defense against non-state actors. Now, it very specifically states that, of course, it refers to two aspects. One is that it refers to customary international law and justifies the right of self-defense. And it also refers to Article 51 of the United Nations Charter. One important part of India's statement was that it also talks about the right of self-defense outside the United Nations Charter, that is outside 51. In other words, it says that there is a right of self-defense even outside the Article 51 of the United Nations Charter. When it refers to customary international law in that sense, it also says that historically this customary international law recognized preemptive self-defense. In other words, even if there is no immediate attack, but if there is a threat of an attack, it can use force. It says that. Then the most unambiguous part of its statement was with regard to Article 51 of the UN Charter. Now it says that, I just quote, Article 51 is not confined to self-defense in response to attacks by states only. The right of self-defense applies also to attacks by non-state actors. In fact, the source of the attack, whether a state or a non-state actor, is irrelevant to the existence of the right of self-defense, unquote. Now, this is probably the most explicit statement coming from India so far on this question of the use of force against non-state actors. And of course, there are several other statements which are part of the same statement which India made. Somewhere I have written that, in fact, this is probably the most expansive understanding of the right of self-defense, even more expansive than many of the global northern states. Of course, there are differences of opinion with regard to other scholars do not agree with that. Now, this was in 2001. As recently as 2024, January, one incident has happened between Iran.
Was that in 2001 or 2019?
This ARIA formula statement is of 2021.
21. Yeah,
21. So this was after Balakot incident. So both in the case of surgical strikes and Balakot, it did not refer to, but in 21, it very specifically spelled out when it made the statement in New York. Arya formula meeting. The other important aspect, which is just recent one, was January 2024. So there was a Iran, they conducted airstrikes against Pakistan against some non-state actors. Now that was happening between India, Iran, and Pakistan. In one of the press briefings, some of the journalists asked the spokesperson of the Ministry of External Affairs his opinion. He said that this is a matter between Iran and Pakistan. Insofar as India is concerned, we have an uncompromising position of zero tolerance towards terrorism. The last sentence is more important. He says that we understand actions that countries take in their self-defense. So here very explicitly stated that it is more on the lines of its Arya formula position, which they have taken. But again, when it comes to Operation Sindoor, and consistently, if you look at from 7th May to 10th May.
Let's hold off on that for a second. Let's hold off on Sindoor. We will end
Yes.
this conversation with a deep discussion in as far as Sindoor and its legality is concerned.
Yeah.
But before that, so as you've said, that India has always argued for, by always I mean for the course of the last few years, has explicitly and unambiguously argued for an expansive understanding of the right of self-defense under Article 51, and certainly that it can be used against non-state actors as well. And it has argued, as we were discussing right at the beginning, that this right could either be contained in 51, which India says it has, or it could be beyond the UN Charter as well, as a case of customary international law where self-defense exists. But my question is really on the threshold. Now, India is saying, as you said, that even an anticipatory action could be justified. So in that sense, if you're talking about an anticipatory action that is justified, the threshold is actually still lower than unwilling or unable, because unwilling or unable is still trying to link that action of that non-state actor to the sovereign state, that the sovereign state is unwilling or the sovereign state is unable to control or rein in these people, and so there is a right to self-defense. But the moment we are saying that we can even anticipate an action from non-state actors and strike, then in that case, the only question is no longer in relation to whether the non-state actor is related to a state or not. The only question is that, is there an armed attack or is there an anticipatory armed attack, whoever it may come from? Do you think that expanded view, number one, is what India is actually arguing for? And if it is not in the context of Sindoor or Pakistan, but as an international lawyer, what is your view of such an expanded doctrine of self-defense, particularly what it does to the general prohibition?
Yeah. Okay, so this takes us back to the Iraq War. The most of the debate about preemptive self-defense or anticipatory self-defense was invoked by the United States before going for the Iraq War. So they were the ones who first mainly used this terminology. And there was a lot of opposition from international lawyers community that this is not provided as part of the United Nations Charter. Nowhere, at least Article 51, it very clearly says that when an armed attack occurs. So which means that if an armed attack occurs, means it has to really occur, it has to happen. So therefore, at least the language of 51 is very difficult to justify any kind of an anticipatory self-defense. It again takes us back to the 19th century, the Caroline test. So there also the incident was involving US, UK, and Canada. There was an attack on a ship. So the argument that is always taken is that, in fact, the anticipatory self-defense and against that can be against non-state actors is possible as part of customary international law, which going back to the origins of the right of self-defense in the Caroline incident. But at least in my view, and there are also other scholars who would argue that this is a slightly problematic position on many respects, not because of India or any other things in terms of international law position. One is that, of course, Caroline incident is quite often relied upon, but strangely, I mean, if you have to look at it as a customary international law one, there was very difficult to say that there is adequate amount of a state practice or opinio juris in support of the, that existed in the last roughly more than 1 century in support of the Caroline. That is in a general sense of state practice and opinio juris. But most importantly, which I find it's problematic, is that when there was no clear prohibition of use of force prior to 1945, there was no need for states to justify their actions under right of self-defense. There were instances of, there were arguments in terms of legitimizing the wars, particularly within the framework of just war and others. But there was no clear emphasis on always on right of self-defense, because the self-defense argument comes only when there is a clear prohibition. Except in 1928 Kellogg-Briand Pact after First World War. But before that, there was no such prohibition. So to argue that the right of self-defense existed as part of customary international law prior to 1945 is conceptually is based on a weak foundation. Personally, I view that. So then coming back to the Iraq war situation, when the US tried to justify its actions, so there was a lot of opposition among international lawyers and some of the states also. So, and the United States understood that probably this argument is not very strong as part of international law. Then it shifted its argument towards the Security Council resolutions, which Iraq did not comply with. Therefore, they went for the use of force. So therefore, where an explicit reliance on anticipatory self-defense happened as part of the state practice, which did not actually receive sufficient amount of support then. So therefore, to argue, it is there. I'm not saying that it does not exist. It still continues to be part of the discussions and scholarly writings and legal opinions, but its foundations are not very strong when we look at it as part of general international law, as well as even going into the customary international law part of it.
And perhaps one would say in response to that, that this is how international law evolves, given the fact that the UN Charter was written at a time when you're still operating fully in the realm of territorial sovereignty, and it is envisaging nation states interfacing and interacting with each other. Of course, that framework is meant for that time. As far as global wars and terror is concerned, as in this is a phenomenon that came up after this phenomenon of non-state actors and this new kind of war that we've been seeing, especially in this case, where no one really, unless there were some mistakes here and there, no one really at least openly crossed a border physically. There were no boots on the ground on the other side. It's essentially continuing to remain in your territory and still fighting a war, like playing a video game in some sense, except the effects are, of course, disastrous. So in that case, given the kind of changed situation in which the world finds itself, the fact that non-state actors have reached a certain degree of significance that we can't say that there is a legal vacuum in relation to their operation, perhaps one might argue that this is a way in which international law evolves, and maybe our effort should be in trying to make it evolve in a fashion that is not overbroad, but at the same time respectful of the developments that are taking place. What would you have to say to that?
Yes. Now, these are the arguments roughly are the ones which you see happening in and around the use of force against non-state actors though it happened predominantly from global northern states, which includes United States, UK, Turkey also does that in terms of justifying its actions. So therefore, that kind of a state practice is emerging. It's not that we say that, okay, that it does not exist. That kind of a state practice is emerging, but even there also, if we look at it, whenever the United States invokes the right of self-defense against non-state actors, somewhere they try to justify it as part of Article 51, and they try to comply with its requirements, like, for example, reporting it to you take action and report it to the Security Council, because that is also a requirement as part of the Article 51. Invoke very clearly inability or unwilling. At least there is a requirement for any state, for that matter, has to explicitly establish its justifications as part of international law and the UN Charter without deviating from it, because it has to go back to the Security Council. If you look at it, the recent incidents also, Security Council at least issued a press statement and said that all those responses to these Pahalgam terror attack have to be in compliance with international law, including humanitarian law, human rights law, and everything, which is, of course, a standard phrase which we come across in most of the Security Council General Assembly resolutions in relation to this. So therefore, it is always, I think, from the point of view of international law, always advised to be clear about, even assuming that the state wants to take this path and justify its actions as part of international. It is always better to justify it within the existing framework. And it is available now. It's not that something that these arguments are not there, one has to create a new path. No, a fair amount of a path is already laid in terms
That's
of
right.
different.
That's
Yes.
right. And if you see in the press conferences that the foreign secretary was doing, it does seem that he was also speaking that language. We heard him continuously say that this was India exercising its right to respond.
Yes.
We also heard him say that all actions were necessary and proportionate, all of which seem to suggest that India's point of view, and continuing with its consistent position in this regard, is that this is self-defense as per Article 51, even though an explicit reference to the same has not been made. So would you agree with that as an international lawyer?
Uh, there, one is, of course, if you look at all the press briefings from May 7th till the end of the hostilities with an understanding reached, the explicit reference was in terms of stating that the right to respond, which is basically right of self-defense. Probably it goes closer to the understanding of the right to self-defense. On the day of on May 7th and later on other press briefings, a reference was also made that the matter has been taken up with Pakistan, but there was no explicit action was taken by Pakistan, which shows probably the actions are sought to be uh, justified as part of the unwillingness on the part of the territorial state, which is Pakistan in this case, which is fine. That is a very invoking the inability and unwillingness. But maybe it is advisable to think of explicitly referring to the right of self-defense very clearly, stating that this right is being invoked, and also maybe complying with other requirements of Article 51 would provide a better justification for actions by any state for their actions if they're involved in actions against non-state actors. The
And
other
I'm
aspect,
speculating here,
yes.
sorry to interrupt you for 1 second, but I'm speculating here, but it was also quite conspicuous that we were not referring to the right to self-defense. We were not referring to Article 51. And I wonder, and of course this is in the realm of conjecture, that is this because of the fact that there is a hesitation in terms of internationalizing this issue, that we want to keep this as a bilateral issue, so we don't want any kind of further internationalization? What do you think could possibly explain that, what seems like a deliberate omission?
Oh, it may not be that because they would like to look at it is in terms of internationalization, because if the way the delegations are going to different parts of the world, members of parliament taking the matter to different parts of the world as a fight against terrorism, seems to be clear that they would like to take it to the international fora as a fight against terrorism. But I think what you raised an important point, which probably needs an explanation. Why this hesitance to explicitly rely on the legal framework? I see it as a kind of a, if you look at it, as I pointed out, if broadly, if we have to look at it, there is a legal framework that UN Charter provides. India was involved in two other incidents of actions against non-state actors, surgical strikes in Balakot, and Arya Formula and Iran-Pakistan incident, then Sindoor. If you look at this sequence, whenever India is involved, it's not explicit, means whenever India itself is involved in an action like surgical strikes or Balakot or Operation Sindoor, does not seem to be explicitly relying on the legal framework part of it. But when it makes a general statement as its policy position, that was evident in the case of Arya Formula. It was very explicit that the right of self-defense exists against non-state actors there. And also when it refers to Iran and Pakistan, it said that the states have a right of self-defense. Now, what does it tell? At least to my mind, it says is that probably this hesitation comes, as I said, that going back to the initial discussion, that this unwillingness, inability, or non-state actors primarily originated from the global northern interventions in various circumstances. So it could be a hesitation based on the fact that probably in what way this, if you invoke explicit legal terms, in what way it would go. Means that today probably I am able to invoke it, but it can also be used against me. So there is an uncertainty about the things that we do not know. So therefore, do not rely explicitly on that. Though you, whenever India speaks at a general fora, it is able to explicitly say that, but whenever itself is involved in it, is not relying on that. So it could be a hesitation, as a conscious hesitation to get into the legal framework where probably the same could go against the not only against India, but in a larger sense of either it's a global southern state. So therefore, that I think is where probably India continues to have that kind of a, it's not an ambiguity, but consciously relying on that framework of a bit of an uncertainty.
I think
So
that conscious ambiguity is good in that sense.
yeah.
Yeah, yeah, because as you said that as a person who believes that the global South should have a stronger voice on matters,
Yes.
and given the fact that there are deep issues conceptually, jurisprudentially, politically with the unwilling or unable test, I think perhaps this sometimes some kind of ambiguity is a good thing, instead of openly claiming because of fully pragmatic reasons, because it suits us in this
Yes.
case, that test would work. But we are almost at the end, but I'd like to end with one question, which is what we began with. Uh, that India, of course, continued to say that it exercised the right to respond, but didn't explicitly invoke international law. Pakistan also appeared to invoke the same right, saying that now it is exercising self-defense against the Indian strikes that have happened. But no one is really discussing legality, as you said. There may have been one or two discussions, but it's really not been very active. So what does that say to the legitimacy of international law? And the point that you made earlier, that while there can be no legal war, the fact is that we are not discussing legality when it comes to a question of war. So, what does that say to you as the growing legitimacy or otherwise of international law?
I think that takes us back to this the divide between global north and global south, even within international law scholarship. Now, I was very carefully looking at it. Had it happened somewhere, like for example, Russia and Ukraine, it had happened, Gaza, Israel, Hamas attacking Israel, Israel attacking Gaza. Now, there is an ample amount of literature that comes uh, in terms of the legality part of it, and either both are justification, countering the arguments. I mean, this is one. I'm not saying that this is the view, but somewhere I see that India and Pakistan both being global South states, somewhere the legality arguments, even within international law, do not take much of a center stage as part of international law discussion. If any of the global northern state gets involved, there is always an immediate discussion with regard to the legality part of it. It of course happens among the scholarship, legal, this thing, even at the institutional level. Global institutions would start reflecting on it in terms of the legality part of it. So it's a larger issue, which probably I think goes much deeper into the global geopolitical divisions that exist. But the point that with regard to the international part of it, it comes back because today only I was reading somewhere, because once you at the go at the global level, these questions would come back. Today, somewhere, I think Shashi Tharoor's delegation was there somewhere in Colombia. I read somewhere that he's saying that we took this action as a matter of right of self-defense. So he was explicit in there. Now that becomes a necessity because once you go reach the global forum, somewhere you need to have these justifications required wherever it takes place, whether it's a Security Council or a General Assembly. So therefore, even if it can be avoided at one level, but it becomes a necessity even to, as part of your diplomacy also it is required sometimes. So we cannot avoid for longer, somewhere it has to come. But yes, Yeah, but in comparison to obviously on many other issues, I feel it is because this global north, global south becomes important, especially with regard to international matters, where the global southern concerns, southern state concerns are there. Somewhere I feel that they do get a lesser attention as part of international discussions. Yeah.
And I think this is where we need Indian scholars, Pakistani scholars, Sri Lankan scholars, other South
Yeah.
Asian scholars, the global South, to all work together to try and ensure that we have a global international law regime that is fair to the global South. Our differences may be there, political and military, but we also must remember that we also have great similarities when we ensure, when we frame the problem
Yeah.
differently. So I think this is also a testament to the incredible work done by several scholars in the movement on third world approaches to international law. Professor Burra, you've been part of that. And today you gave us a glimpse on how international law has developed, how India has helped shape international law, and how India is also has this kind of constructive ambiguity on certain questions in relation to self-defense and the use of force. And I think it's trying to balance many things, but there is a long way to go before the global South makes a dent in making the international law regime just, fair, and equitable. So thank you very much for your comments. It was really enlightening to hear you. I'm sure this was a great lesson for all of us who are listening on the international law aspects of Operation Sindoor, as well as the right to self-defense. Thank you very much once again, Professor Burra.
Thank you. Thank you so much, Adam. Thank you.